Henry A. Goodman, Esquire, licensed in Massachusetts, Rhode Island, and Florida, is a principal and co-founder of Goodman, Shapiro, and Lombardi, LLC. A major portion of Mr. Goodman's practice is devoted to condominium law, corporations, general real estate matters, and heavily involved in civil litigation. The first attorney in Massachusetts to concentrate in the representation of condominium associations, he was involved in the initial drafting of the Massachusetts Superlien Law. He is a member of the Board of Governors of the prestigious College of Community Association Lawyers, and has held other high national positions as well as local positions. Mr. Goodman is a highly regarded lecturer, author of articles and appellate court briefs on issues important to condominiums and cooperatives on a state and national level.
Everyone who purchases a condominium unit in Massachusetts and in most states in this country are deemed to presume what is known in the condominium documents. They're presumed to know all of the rules and restrictions that are contained in those documents. One of the biggest issues that condominium boards always seem to face relate to ignorance or lack of awareness of the regulations and restrictions by a unit owner. So every condominium unit owner is hereby placed on notice that they should read the condominium documents. They should be mindful of the restrictions in those documents, and they should be satisfied that they are willing to comply with those restrictions. If not, don't buy because they're going to apply to you. Most importantly, unit owners should understand that the board can make administrative decisions that will adversely affect them. Unfortunately, some condominium owners think that rules were not meant for them. In the following example, there are owners whose cigarette smoke or cooking odors waft into a neighbor's unit. The principles for those situations can apply to almost any infraction. Smoking in residences is legal. Most buildings are built in a way that allows smoke and cooking odors to waft through the common area space between the units and enter the neighboring unit. The neighbor then complains to the board. The documents say no owner can do anything in his unit that will be an annoyance to his neighbors, and that the board shall enforce those restrictions for the benefit of all owners. This creates a contractual covenant of quiet enjoyment that otherwise does not exist in condominium law. As a board member, when you have such a complaint, what do? Well, first of all, you have to investigate the complaint. The offended person may be overly sensitive, and the odor might be something one should reasonably expect to live with. If the smoke is from marijuana, the board may have to make a reasonable accommodation to avoid violating the laws against discrimination, because marijuana may be for a medical problem. Some cooking odors are traditional. Ethnic recipes may have to be tolerated to protect the board from a discrimination claim based on national origin. If the odors become unreasonable and are adversely affecting another handicapped owner, action to prevent the odor may have to be taken to prevent an otherwise lawful activity. We can review your documents to see if you need an amendment to address these issues. However, if the odors continue to be a problem, the board may have to issue fines or go to court to prevent an uncooperative person from being a continual annoyance to others. The board may even find it necessary to consider retrofitting the building to prevent the spread of the odors. This is something that you do not want to do. We can help you prevent some of these problems.
For more information on these and other related subjects, contact the partners at Goodman, Shapiro, and Lombardi, LLC. Their toll-free number is 877-241-1600, or go to their website at www.goshlaw.com. Goodman, Shapiro, and Lombardi, LLC. The right attorneys to call before the wrong thing happens.